We all hear about people turning toward the courts of law to resolve disputes on matters such as divorce and parental custody. But have you ever wondered what goes on behind the scenes when someone goes to court? The answer lies in the litigation process. Now, the word litigation sounds like an intimidating word you would hear from a lawyer, but it really just refers to using the court process to arrive at a resolution when parties in conflict cannot reach an agreement on their own. When it comes to family law, it can be challenging to reach an agreement on such things as a parenting schedule, decision-making for the children, where the children will reside, support, and how to divide property. As a result, parties sometimes have to engage in the court process so that a judge or justice can help decide things. This can be an effective way of bringing a conflict to an end. Therefore, it is important that you know about the process of litigation and the mechanisms people may have to go through before they arrive at a solution. Today, we look at the litigation process in Alberta's Court of Queen's Bench from a general point of view. It is important to note that in Queen's Bench, the judge is referred to as a justice. Judge is a term used for provincial court judges. The entire process can be broken down into 4 simple stages. Number 1. The first stage involves initiating the court action. The litigation process starts with the party who initiates the court action. This person is sometimes referred to as the plaintiff and sometimes as the applicant. For ease of reference, we will use the term plaintiff. The plaintiff initiates a claim by filing it with the courthouse. The claim details what they are asking for and the reasons behind their claim. A lawyer can assist the plaintiff to formulate their demands clearly and accurately in a claim or statement of claim, depending on the subject matter. It is important to ensure that this document is thorough and accurate, as there can be barriers to changing or adding demands later on. Then, the plaintiff must personally serve the other side of the dispute, known as the defendant. In some cases, the responding party is referred to as the respondent, but we will use the term defendant. Whoever serves the defendant must file a sworn affidavit confirming that the defendant has been served. The defendant is then able to respond to the claim made by the plaintiff by filing a statement of defense or a response, depending on the situation. They may also file a counterclaim outlining their own demands. The plaintiff must be served with these documents, and they may require an additional response. There can be more than one plaintiff or applicant and more than one defendant or respondent. Regardless of the number of individual parties, the process remains the same. Number 2. The second stage is called discovery. In family law cases where support or property are at issue, it is common for one or both of the parties to file and serve a notice to disclose. This document outlines the financial disclosure that the parties are required to provide one another and comes with a court date to ensure that this information is being exchanged. Failing to exchange disclosure can lead to penalties and deadlines being imposed by the court. Also, at various points in the process, the parties can gather facts about the case in order to bolster their own positions. There are 2 ways in which they can do this. They could engage in a process called questioning, in which either party can question the other one about matters relevant to the litigation. This is done under oath and in front of a court reporter who writes down everything that is said. During questioning, parties can request additional documents from the other party. The party asked to furnish documents is responsible for providing all legally relevant information and documents that are in their possession or can be retrieved from third parties. Failure to comply with this request can lead to penalties, deadlines, and costs. At the end of this stage, most of the important facts relevant to the case are discovered and brought to the table. At any time, a party can initiate Stage 3, making a court application. In this stage, a party can make an application to appear at court, asking the court to make a decision based on the sworn evidence provided in the form of an affidavit. The opposite party can then respond to this application by sending in their own sworn evidence to the court, again in the form of an affidavit, and may also decide to file a counterclaim. Rules about this process, including the forms and procedure, can be found in the Alberta Rules of Court and relevant legislation. Family applications are typically heard in 2 settings. regular chambers, or special chambers. Regular chambers is usually reserved at least 5 days down the road and used for matters that take 20 minutes or less to argue, with 10 minutes allotted to each side to explain their argument and their supporting evidence. Special chambers, as the name hints, is usually reserved months in advance and is used for cases with multiple issues or involving more complex matters. Special chambers can be an hour, a half day, or a day long. Special chambers typically also rely on sworn evidence, and there are very specific filing requirements for special chambers, including a letter to the deciding justice outlining legal arguments. There are some cases where the court will require oral evidence in order to make a decision. Typically, however, most applications rely on sworn evidence only. Note that the orders granted during this phase are interim orders, meaning that they are not final. These can be reviewed during the next stage, which is number 4, the trial. This is the stage you are likely most familiar with. You must have seen this in movies or maybe even in real life, when both parties meet at the court in a session overseen by a judge or justice. Witnesses take oath, present their statements, and answer questions. Lawyers from both sides make their arguments, and in the end, the justice makes a final decision. This brings a formal end to the case, with the decision of the court being final, unless it is appealed. It is important to note here that very few cases actually go to trial. Interim orders can be viewed as final by the parties if they do not proceed to trial. Prior to attending trial in the Court of Queen's Bench, family cases in Alberta must attempt some type of mediation or alternative dispute resolution in advance. This means that both parties will try to come to a settlement with each other, agreeing on terms that bring the case to an end. Only if this is not successful do cases then proceed on to trial. The parties may attempt to engage in mediation or alternative dispute resolution at any point, including before the court process even starts. It may still be necessary to initiate the court action if the parties have reached an agreement, but require a court order in order for that agreement to take effect. And that brings us to the end of the Alberta Queen's Bench litigation process and this video. Remember that this video should not serve as a substitute for legal advice, and that you should always consult a lawyer if you have questions about your own circumstances. We hope you enjoyed learning about litigation and are now thirsty to know more, because we have a lot more in store for you. Stay tuned for our next video, in which we will talk about the mediation process. For more information, please contact Caliu Law. We offer all of the described services and more, and are happy to discuss your case with you.